3 children were dying inside their family home. Their father had been gone for less than an hour. When he returned, nothing would ever be the same. Within hours, investigators knew who was responsible. There was no manhunt, no mystery suspect, no decades-long search for a killer. Lindsay Clancy admitted she was the one who killed her 3 children. For most murder cases, that's where the story ends. This one was only beginning, because more than 3 years later, the people closest to this case still cannot agree on the most important question of all. Did Lindsay Clancy knowingly murder her children? Or was she experiencing a catastrophic psychiatric illness so severe that she could no longer understand the reality of what she was doing? The answer isn't just a matter of opinion. It could determine whether she spends the rest of her life in prison or whether the law concludes she was not criminally responsible. Here's what makes this case unlike almost any other. The prosecution and the defense are looking at many of the same pieces of evidence, the same medical records, the same psychiatric evaluations, the same medications, the same hospitalizations, the same text messages, the same internet activity. Yet they have reached 2 completely opposite conclusions. One side says the evidence reveals planning, awareness, and intent. The other says it documents a woman descending into one of the rarest and most devastating psychiatric emergencies known to medicine. Both cannot be right, but one of them is. And somewhere inside thousands of pages of medical records, witness testimony, digital evidence, and expert opinions lies the answer that 12 jurors have been asked to find. To understand why this trial has divided psychiatrists, lawyers, and the public alike, we have to go back to the months before January 24th, 2023. Because this story didn't begin on the day 3 children died. According to both sides in the courtroom, it began long before that. The disagreement is over what those months actually reveal. Were they warning signs of a mind steadily losing touch with reality, or evidence that, despite serious mental health struggles, Lindsay Clancy still knew exactly what she was doing? That is the hardest question in this trial. And by the end of this documentary, you'll understand why answering it has proven so extraordinarily difficult. Months before January 24th, Lindsay Clancy was already asking for help. She saw mental health professionals. She described worsening anxiety and depression. She struggled with severe sleep problems. She reported intrusive thoughts and suicidal thinking. And as her symptoms continued, her treatment changed repeatedly. The prosecution does not dispute that Lindsay was suffering. In fact, several witnesses who treated her described a woman experiencing significant psychiatric distress. The disagreement is what that distress proves. Dr. Jennifer Tufts, Lindsay's treating psychiatrist, testified that she diagnosed Lindsay with postpartum anxiety and depression and did not believe she was psychotic during the period she treated her. Tufts also testified that Lindsay never told her she was hearing voices or intended to harm her children. That testimony became important for prosecutors, because Tufts wasn't looking at Lindsay years later. She was treating her before the killings. She saw her symptoms as they were happening. The prosecution wants jurors to consider that first-hand observation. But the defense attacked the treatment itself. Tufts acknowledged that her appointments with Lindsay were conducted remotely and were generally brief. Defense attorney Kevin Reddington also questioned the medication decisions made while Lindsay's condition was deteriorating. That creates the first major conflict. The prosecution asks, what did the clinicians actually observe? The defense asks, what did those clinicians fail to recognize? And the difference matters, because a diagnosis recorded in a medical chart does not automatically settle what was happening inside a patient's mind. The records show serious illness. They do not, by themselves, answer the legal question. One of the most troubling parts of Lindsay's history involved intrusive thoughts. Witnesses testified that Lindsay had reported disturbing thoughts involving harm and had also experienced suicidal thinking. But there is an important distinction. An intrusive thought is not automatically an intention. Someone can experience a frightening thought and be horrified by it. Someone can also recognize that a thought is unwanted and seek help precisely because it frightens them. That distinction became significant in Lindsay's treatment. The prosecution points out that she communicated about her symptoms. She attended appointments, she asked questions about medication, and she did not tell her providers that she had decided to harm her children. The defense sees those same facts as evidence of something else. A woman was telling people she was struggling. She was describing changes in her thinking. Her sleep was deteriorating. Her emotional state was deteriorating. And yet the care she received did not prevent the catastrophe that followed. That does not prove the defense theory, but it creates an uncomfortable question. How much can a medical record tell us about an illness that professionals themselves may not have recognized correctly? Then came McLean Hospital. In January 2023, Lindsay underwent inpatient psychiatric treatment. By that point, her condition had become serious enough for hospitalization. The prosecution points to the diagnosis made during that admission and to the absence of a documented diagnosis of postpartum psychosis. The defense points to something simpler. She was sick enough to require inpatient psychiatric care. And shortly after returning home, the tragedy happened. Neither fact settles the case. The prosecution argues that the hospitalization shows Lindsay had access to professional treatment and was evaluated by specialists without being found psychotic. The defense argues that psychiatric hospitalization is not a guarantee that every aspect of a patient's illness will be recognized. That disagreement became even more important as additional providers took the stand. A psychiatric nurse practitioner, Rebecca Gelada, described symptoms that included severe insomnia, suicidal thoughts, and increasing distress. She also testified about repeated concerns involving medications. Under cross-examination, however, she acknowledged that she did not have access to all of Lindsay's treatment information from other providers. Then came another provider. Social worker Latiacia Dukes testified that she had no major concerns about Lindsay's immediate safety during their sessions, even though Lindsay had described significant distress and passive suicidal thoughts. Dukes also acknowledged that she had not reviewed notes from Gelada that documented additional symptoms, and suddenly, the medical history looked very different. It wasn't simply a story about one doctor reaching one conclusion. It was a story about several professionals seeing different parts of the same patient. One provider documented one set of concerns. Another provider saw something else. Information did not always travel between them, and the defense has seized on that gap. Because if different clinicians were working with different pieces of information, how confident can anyone be about what they collectively understood? The prosecution has its answer. Those clinicians still saw Lindsay repeatedly. They still evaluated her, and none concluded before January 24th that she had lost touch with reality. Again, the same record, a different conclusion. Then the timeline reaches the day everything changed. Patrick Clancy testified that Lindsay appeared to be in a good mood during the day. She spent time with the children. She sent him photographs. They communicated about ordinary household matters. Later, she contacted him about dinner. According to his testimony, she asked whether he wanted takeout, and he went out to pick it up. Patrick said they also discussed medication while he was away. That sequence has become central to the prosecution's theory. Because prosecutors say the decision to send Patrick out created the opportunity for Lindsay to act while she was alone with the children. They don't present that as an isolated event. They place it inside a larger timeline, a decision, a period of time, an absence, and then the deaths. To prosecutors, that looks deliberate. The defense challenges the interpretation. Their argument is not necessarily that Patrick's absence did not happen. It did. The question is why. A request for dinner can be ordinary. The prosecution says it was purposeful. The defense says prosecutors are interpreting an ordinary action through the knowledge of what happened afterward. That distinction is fundamental, because if the jury accepts the prosecution's interpretation, the timeline becomes evidence of planning. If the jury accepts the defense's interpretation, The same timeline becomes much less conclusive. And then, investigators found the digital record. The phone became a window into the weeks leading up to January 24. Investigators found searches involving psychosis, hallucinations, mental illness, suicide, medication side effects. There were also searches relating to other deeply disturbing subjects. One search specifically asked whether a sociopath could be treated. That search occurred only days before the killings. Prosecutors highlighted it because of its timing. Why was Lindsay researching these subjects so close to January 24? The defense has another explanation. Perhaps because she was desperately trying to understand what was happening to her. That interpretation is supported, they argue, by the broader pattern of searches. The phone did not contain only one category of information. It reflected questions about her own mental state, her symptoms, medications, and death. That makes the digital evidence powerful, but not simple. A search is evidence of a question being entered. It is not automatically evidence of the answer the person believed. And that distinction matters enormously here, because prosecutors want jurors to infer awareness from the searches. The defense wants jurors to see them as evidence of a psychiatric crisis. Then the search history became even more complicated. A search related to suicide methods was associated with a device used by Patrick, but testimony left uncertainty about who actually made the search. That means even a piece of digital evidence that sounds definitive can have an unresolved question at its center. Who made the search? Why was it made, and what did it mean? The jury cannot simply assume. They have to weigh the evidence. Then there was Lindsay's private writing. A note found on her phone expressed feelings of failure and inadequacy as a mother. It described emotional disconnection and deep distress. It was written months before the killings. To the defense, it is another piece of a long deterioration. A woman who felt overwhelmed. A woman who believed she was failing. A woman whose emotional state had become increasingly unstable. The prosecution does not need to deny any of that. Their argument is different. Depression does not automatically eliminate criminal responsibility. Despair does not automatically eliminate criminal responsibility. Even profound mental illness does not automatically mean a person was incapable of understanding the wrongfulness of an act. That's why the legal question is so much narrower than the emotional question. This is where the wording of the law becomes critical. Massachusetts does not simply ask whether Lindsay was mentally ill. It does not ask whether she was depressed. It does not ask whether she was experiencing postpartum symptoms. And it does not ask whether her behavior looks irrational in hindsight. The state's criminal responsibility instruction focuses on whether a mental disease or defect caused the defendant to lack the substantial capacity to appreciate the criminality or wrongfulness of her conduct, or to conform her conduct to the requirements of the law. And the burden remains on the Commonwealth to prove criminal responsibility beyond a reasonable doubt. That changes how the entire trial has to be viewed. The question isn't, was Lindsay suffering? There is overwhelming evidence that she was. The question isn't, did she have mental health problems? She plainly did. The question is whether those problems reached the legal threshold that removes criminal responsibility. That is much harder to establish. And it explains why the medical evidence matters so much. Because every record is potentially evidence about her capacity. Every conversation, every search, every decision, every observation. The prosecution's theory is not that Lindsay had no psychiatric problems. It is that those problems did not destroy her criminal responsibility. They point to the months of treatment, her ability to communicate, her interactions with professionals, her behavior on January 24th, the timing of Patrick's departure, the digital evidence, and the sequence of events. Put together, prosecutors say these facts show a woman who understood what she was doing. The defense asks jurors to interpret that same sequence differently. They point to deteriorating sleep, intrusive thoughts, suicidal thinking, medication changes, conflicting assessments, the hospitalization, the breakdowns in communication between providers, and the digital searches that they say show Lindsay was struggling to understand what was happening inside her mind. The defense's position is that organization does not automatically equal sanity. Someone experiencing psychosis may still be capable of performing familiar tasks. They may communicate. They may use a phone. They may appear composed. What matters, according to the defense, is not whether Lindsay could perform those actions. It is whether she understood the reality and wrongfulness of what she was doing when the killings occurred. That is the question the expert testimony will ultimately have to address. And as of August 15, 2026, that testimony is not complete. This point is crucial. There is still no verdict. The prosecution has been presenting its evidence for roughly 3 weeks, and the case is now approaching a pivotal point as the Commonwealth nears the end of its presentation. That means this documentary cannot honestly tell you that the experts have already settled the issue. They haven't. It cannot tell you what the defense's complete psychiatric case will ultimately show. That hasn't happened yet. And it cannot tell you how 12 jurors will interpret the evidence. We don't know. What we can examine is what has already emerged. And what has emerged is unusually complicated. The treating professionals did not all see the same patient. The defense has highlighted gaps in communication between providers. The prosecution has emphasized Lindsay's repeated interactions with the healthcare system and the absence of a documented psychotic presentation from some of those clinicians. The phone contains searches that can be interpreted in radically different ways. The timeline contains actions that can look deliberate when viewed backward, but can also be argued as ordinary behavior by the defense. That leaves the jury with a problem that cannot be solved by one dramatic piece of evidence. Imagine having to make the decision. You know the outcome. 3 children are dead. You know Lindsay Clancy was their mother. You know she was deeply unwell. But now you have to answer the question the law actually asks. Did she understand the wrongfulness of what she was doing? Or did a mental disease or defect so fundamentally alter her thinking that she lacked the substantial capacity required for criminal responsibility? The prosecution says the evidence shows awareness. The defense says it shows psychiatric collapse. And neither side can simply erase the evidence supporting the other. The treatment records are real. The searches are real. The text messages are real. The hospitalization is real. The conflicting medical assessments are real. The question is what those facts mean when they're placed together. That is why this case is not simply about whether Lindsay Clancy killed her children. That part of the case is not the central dispute. The harder question is what was happening inside her mind at the moment she acted. And that question cannot be answered by emotion alone. It cannot be answered by sympathy. It cannot be answered by anger. It cannot even be answered by the fact that someone had a diagnosis. It has to be answered through evidence and the legal standard, and right now that process is still underway. There is no verdict to interpret. There is no final expert consensus to report. There is only an evolving courtroom record in which the same facts continue to support 2 radically different explanations. One explanation says Lindsay Clancy was suffering but still understood the wrongfulness of her actions. The other says the illness had gone much further, far enough to destroy the capacity the law requires for criminal responsibility. That is the question 12 jurors will eventually have to answer. And when they do, they won't simply be deciding how to interpret one terrible day. They will be deciding what those months of treatment meant, what those searches meant, what those conversations meant, and ultimately, what Lindsay Clancy understood when everything changed. That is the hardest question in this trial. And until the evidence is complete and the jury reaches its decision, nobody outside that jury can honestly claim to have the final answer. Please subscribe to this channel for more carefully researched true crime documentaries that go beyond the headlines and examine the evidence, the unanswered questions, and the arguments shaping major cases.